Thank you for Andrew, for the introduction and the opportunity to speak. And I know this isn't one of the most glamorous issues in the community, but I do think it's an important one, and it's going to become increasingly important for some of the reasons that I'll describe. So, my name is Kevin Pomfret. I'm a lawyer, but I also am the founder and the executive director for the Center for Spatial Law and Policy. And the mission of the center is to just raise awareness about the legal and policy issues that are impacting the collection, use, and distribution and storage of geoinformation. And unfortunately, there is a lot of issues associated with this new technology, but there aren't a whole lot of the legal and policy communities are quite far behind from what you're doing from a technology standpoint. So the goal of the center is just sort of raise awareness about these issues. So why is this important? A couple of reasons. One is that geospatial products and services are increasingly being developed using data from a variety of sources. So we've got government data, we've got industry, both proprietary and open data, and then increasingly we've got the crowd. And as you try to sort of put these data sets together, many of them are subject to licensing or data sharing agreements, each with their own restrictions or requirements, terms of use. And it's going to become, if it hasn't already become for you, increasingly important to understand what these are and how they relate to one another so that you could figure out what you can and can't do. And I think a lot of people that I've talked to says, well, we're just a software company or we're just a data provider. These issues aren't that important to us. There's someone else down the geospatial ecosystem that it's important to. But I believe that increasingly this will be an important issue for everyone to understand the data that they're either using or even touching along their way, whether they're hosting it or aggregating it or putting it in the cloud. So I'm just going to talk through, in general terms, these 5 sort of high-level issues and why I think they're important so that you can have a better understanding as to what a lawyer looks like when they're looking at a license agreement and why some of the terms are in there or some of the issues that they'll discuss. So the first is just defining the rights and the intellectual property, and that includes both the data and, in many instances, the metadata that you have. And this is important for lots of reasons. One, to make sure that it's clear between the parties what rights that you have and what rights that you're granting to them. There's not a whole lot of body of law around these issues, so if you look to lawyers or judges to sort of resolve it in the event of a dispute, you're really putting it in the hands of someone who could come up with a variety of decisions that would be surprising, if not only just disappointing to you. It's also important because the issue of copyright around facts, as most geospatial data sets are facts, is really difficult right now to understand, and it's important to understand both what copyright law applies to the data that you're either licensing or receiving in a license, but what that means in terms of what you can and can't do, whether you can create derivative works, whether you can distribute it, what does it mean to display it in a geospatial environment. So increasingly these issues are going to become important, and to the extent that you can have those in your license agreement, the better off you'll be in the event that there's a dispute down the road. A related issue to that is defining the use rights. So once the parties understand, what rights they have with respect to the data, an important component of that is how can the licensee use the data. And geospatial data, some of the power of geospatial data is its versatility because it can be used for a lot of different things. So you may not necessarily know how the data is going to be used if you're a licensor or a licensee. And so trying to address that early on, or at least to discuss it, will help you sort of get to a point so there's fewer disputes down the road. One of the problems that happens in failing to address how it's going to be used is the data may be used for purposes that it's not suited for. And that could increase the risk of harm or injury to individuals or property. And the risk of harm really goes 2 ways. So one is to the impact to a third party that's not part of the agreement, and another is the potential impact to damages to one of the other parties who suffer harm because the data is used in a way that is not either contemplated or not necessarily suited for. But another important reason to consider use is, as we talked about, geospatial data is very versatile, and in this rapidly evolving marketplace, it can be used for a lot of different purposes. but you may not want your licensor, or the licensor may not want the licensee to use it in all the different markets or for all the different products. They may want to keep it for themselves in order to use it for a different, to license the data set to another licensee for another product or in another region. And so it's important to have that in mind as you enter into a license agreement, both as a licensor and licensee, as to what it is that you want to use it for, and making sure you get those rights spelled out clearly. So again, in the event of a dispute, you're not leaving it to a lawyer or a judge who doesn't understand the technology and really doesn't understand geospatial information to make that decision. So then the payment terms. Again, that's an important consideration and one that a lot of people give thought to, but I think there's a couple different ways you may want to think about it. So one is certainly cash. Payment could be immediate or it can be paid over time, over quarterly or whatever makes sense from a business standpoint, or it also can be a royalty if data is being included in a product or service. If you're the licensor, you may want to take a percentage of the money that's being generated from that product or service, but that would typically requires making sure that you have rights to audit how that data, how much of the product is being sold, and discussing on what terms those might apply. You also must, in this global economy, think about what currency you're going to be paid in. And then often you see where there are in-kind payments. So someone may provide services or data back in exchange for data, maybe improvements to the data as part of the consideration. And in those instances, you want to make sure that they have reciprocal obligations, as we're going to discuss here, about representations and warranties and covenants and indemnifications, because now you're not only, if you're the licensor, you're also the licensee of additional data. Another component is allocating risks, and this is something that lawyers are, very sensitive to. A lot of time the business folks don't necessarily want to think about these risks because they don't want to upset the other party to the negotiation, or they think that they can work it out. And in many cases you can, but it's at least important to understand what the language in the agreement provides, standard language, and how your lawyers are thinking about it to see if you want to address some of these risks head on, and then instead of just letting boilerplate language address it. So for instance, if you think about data and it's increasingly being used in a variety of real-time critical decision making, and a lot of times this is being pushed down deeper into organizations with people who don't really understand the technology, the limitations of geospatial data, you really increase the risk of mistakes being made and parties being injured. And again, do you want lawyers and judges to decide the liability, or do you want to put that in the agreement? And that runs sort of through in terms of representations and warranties with respect to accuracy or timeliness or completeness, but also towards uses and rights and data, to just have a full understanding of what the various things could go wrong and how you want to deal them in your relationship. An issue that I'm going to talk a little bit about is sort of the changing perceptions of privacy with respect to geospatial data and location in particular over the past few years. So here's a picture from 2005 that was published by an AP reporter. It's in St. Peter's Square. It's in conjunction with the, I believe it's a death of a pope, and I apologize, I forget which one, but you see a number of people sort of looking down the square, waiting to see someone give a talk or some signal in terms of the Pope's arrival or the election of a new Pope. And that was in 2005, and here's a similar picture in 2013 of St. Peter's Square, and you see sort of the same general angle, again in connection with the election of a new Pope, I believe. But you can see in those 8 short years just the abundance of people holding up cameras, iPhones, iPads, other mobile devices, taking pictures. You know that they're tweeting their pictures, they're chatting on Facebook as to where they are, they're sharing information about themselves and the people around them on a real-time basis. Yet I would argue that given all increasing tensions and concerns about location awareness, that they are more concerned about their location privacy now than they were in 2005, even though they're the ones that are sort of distributing and sharing the data by choice, in addition to having everyone else share that data. So I describe that as sort of the privacy paradox, and it's something that I think increasingly the geospatial community is going to have to deal with, because location and location privacy are something that policymakers and regulators and the media are paying closer attention to. So, for example, the Federal Trade Commission, which in the United States is sort of the primary de facto government organization regulating geospatial information is starting to look at mobile app developers that are collecting location information without the consent of the consumer. And even though there hasn't been any legislation that directly refers to location information as being sensitive, the FTC has basically deemed it as such, and they have entered into settlement agreements with a couple of companies, and this one, I believe, back in March of 14 was a flashlight company, a flashlight app that for some reason was collecting location information without consent. And so this is a settlement decree that they entered into. There's been a more recent one. I believe it was I shouldn't say, it might have been the WhatsApp, but there was another settlement negotiation recently, again having to do with geolocation information. So the regulators are looking at this in terms of location privacy. And I think this issue is going to be even bigger when we start having new privacy technology, location privacy technologies enter the marketplace. So I think drones are certainly going to be one that we're going to have to deal with in the future. There's already been a number of states who have introduced legislation that would restrict the ability of UAVs to collect location information, imagery, or other types of location information. And even the Supreme Court is impacting sort of privacy law with respect to location. So there was a case back in 2012, U.S. v. Jones, where for the first time a majority of the justices seemed to say that if you can collect enough information about an individual's location and movements over time, even if it's in public space, you may infringe their privacy or reasonable expectation of privacy. And that's a significant change, because it had always been assumed that you can, as long as you were tracking someone's movements in public space, there was no expectation of privacy, or there wasn't a reasonable expectation of privacy in a public space. But that seems to be changing now, and the potential impact that that's going to have on the geospatial community could be significant. And as I tie this back into licensing, I think it's important to make sure that if you're licensing data, that the licensor has complied with applicable laws, and also making sure that if you're the licensor, that your licensee is going to comply with applicable law, so that you're not somehow responsible or deemed responsible by a regulator or a court as being infringing on someone's privacy. And then even the legislatures are getting involved. So this is Location Privacy Protection Act of 2014. Similar legislation was introduced in 2013. I took a quote from that act requiring companies that collect location data over 1,000 or more devices. They'd have to explain how they collect it and who they share it with and how they use it and how people can stop the collection or sharing of that data. I don't have any expectation that this bill is going to pass anytime this year or anytime soon, probably, but I do think it shows that location information is moving into the mainstream with respect to privacy, and there will be increased attention to it, and I encourage companies and organizations to think about that as part of their privacy, as part of their licensing regime, and protecting the privacy of particular individuals they may be collecting. And then the final component of licensing is to consider applicable law and other technical legal issues associated with license. And there's a variety of these, and I think it's interesting from a geospatial standpoint, because it's the community and the technology has made it so easy to collect, use, and share data across geographic regions and national lines and jurisdictions. But we need to understand that the law is still tied to location, right? It's tied. I can do things here in Virginia that I can't do in Maryland, and that I can't do in Europe or China. That's sort of the world that we live in. So when you're dealing with lawyers who are working on license agreements, who are been trained or to comply with the law of their local land, it's important to realize that the licensee or the licensor in another country or another part of the world may have a different perspective on things. And in making sure that you understand which jurisdiction's laws applies in the event of a dispute, where the proceedings will take place, and that's generally to make sure that if it's helpful if a proceeding is closer to you rather than further away from an expense standpoint. Increasingly, organizations look to arbitration or mediation rather than a full litigation to resolve disputes, particularly if there's a sense that it's going to be a complicated case, and they may want to have some experts make the decision rather than someone who is a layman or not trained in the technology. think it's important to think about force majeure, which is simply, when is performance not possible, event of major catastrophe or event of wars. Sometimes it's important to consider about assignment, whether you want to make sure that someone can transfer their rights in the license agreement to a third party. You may not want that. You may not want them to transfer it to a competitor, for instance, or you may not want someone who you're licensing data from. If they were to transfer it to someone else, you may want to consider, whether you had a right to get out of the agreement because you no longer felt you could trust the data provider. Again, compliance with laws, I talked about that, particularly with respect to privacy, making sure that your other party complies with local laws, some of which you may not even know of. And I often suggest to people think about insurance and whether insurance can address some of the risks that are that are arising from the transaction that's taking place. And unfortunately, the insurance industry, like many others, is catching up to this. I know I've done a little research regarding UAVs and insurance around UAVs, and there's still a great deal of risk that the insurance companies are not willing to take with UAVs, although that is slowly changing. But at least understanding what risks you can insure against and what the costs are, I think, is an important consideration. And so that's it. I'd be glad to, answer any questions. I appreciate this time. I just thought it was important to sort of give a high-level overview of licensing geospatial data, given sort of the trends that I see, anyways, in the geospatial community that applies to both industry and government.
Thank you, Kevin. And for those who are watching the live stream, if you'd like to ask a question, you can do so via Twitter with the Locationtech hashtag. You can also do so via the Locationtech IRC channel on Freenode, or you can email info@locationtech.org, and we'll relay the questions to Kevin. So there's a few questions that we've already relayed, and I'll scan in the background while Kevin's answering.
Okay, so I think the first question is, for geospatial data, is there a set of well-known licenses similar to well-known open source software licenses? There are licenses that people are using. I don't know how well known they are, but I think a lot of people in the open data communities are at least aware of them. There's the Creative Commons licenses that are being used, although many people, including myself, don't think that they're necessarily applicable to data. They're more applicable to content such as music or art or written words, books, and things like that. There's also the Open Database license and the ODBL that has been adopted by OpenStreetMap for one, and I assume others. I've worked with that license some. I've taken a look at it and reviewed it, and I do think it's it needs some work. I think the intent is the intent is good. I'm not sure that it's been specifically tailored enough for geospatial data to address some of the concerns, and I personally believe that there are some unique issues associated with data that you don't have with software, so it's going to be a more difficult license to come up with for universal adoption. The second question for today's geospatial data license is, what are some of the key differentiating characteristics? I'm not sure I understand that question. Maybe the person can, I'm not sure it's differentiating between the different types of data or difference between data and software license. So maybe if that person could submit a follow-on question that could help clarify, that would be helpful.
Okay, what I'll do, Kevin, is I'll encourage them to post on the video. So this video will be in YouTube later this afternoon. And if people have any follow-on questions or to clarify that last question, people can do that, and I'll help you monitor that, so that way we can take the discussion to the YouTube comments section. So sure. I don't see any other questions at the moment. I'm just going to do one more quick refresh to see if anybody's got any questions that I missed. Not at the moment, so we'll take it to the video comments. And I just wanted to thank you again, Kevin, for coming and sharing your knowledge. We really appreciate it, and thanks to the viewers who participated today.
Thank you. I appreciate it as well.
All right, great. So this broadcast I'm going to try to stop, and we'll have the recording available in YouTube. So thank you, everyone.